So not only
How
did they
could they do that?
I've seen insurance companies do some things that I don't think they should be proud of. But I've never seen an insurance company engaging in an intentional tort like this, an intentional interference of contract.
All right, I just want to say good morning to everyone and welcome you to the Wednesday, October 23rd, 2024 Law in Motion calendar. We're going to proceed in case order set forth on the calendar and call the uncontested matters first, and we'll go to the contested cases. Okay, we're going to move on. Next up, page 6 of the calendar. Brian Gallagher versus Affinity Lifestyles.com Inc. et al. Thank you.
Good morning, Your Honor. Spencer Kook of Henshaw Culbertson on behalf of the insurers, third-party defendants.
Good morning.
Morning, Your Honor. John Carlson, bar number 10536 here is the counsel of Mr. Cook.
Okay, good morning.
Good morning. Good morning, Your Honor. Joel Adu on behalf of Rural Water Gold Coast.
Good morning, Your Honor. David Spurlock, United Natural Food Plus.
Your Honor, online, Jim Neale, also on behalf of UNFW.
Good morning, Mr. Neale.
Morning, Your Honor.
Will Kemp on behalf of the Gallagher third-party claims.
And good morning. So did I give you back the calendar? Yeah. That's okay. Okay, so where do we go as far as this matter is concerned? We have multiple matters on calendar this morning.
I think we have a motion to associate that we should probably do first.
Yeah, I think we granted those, right?
And through,
They were unopposed. We signed orders, right?
This morning.
This morning.
very nicely, Your Honor.
Yes.
Thank you.
Your Honor, then the easy one's the motion to amend. We filed a motion to amend. UNFI did an opposition with the question, and we answered the question. Now I think there's no opposition. So
I think I read that this morning.
I think everybody's fine with the motion to amend, and it should be granted.
Is that true? Once there was clarification?
Your Honor, Jim Neale. Thank you, Dave. Your Honor, Jim Neale for UNFW. I think Mr. Kemp and I agree that probably better to characterize what we filed as a effort to clarify. And I think Mr. Kemp and I are on the same page, but so that the record's clear, you'll recall, Judge, that we filed a third-party complaint against Real Water Tennessee and Real Water Gold Coast. Those are counts 1 through 3 of the proposed third amended third-party complaint. We have resolved that claim against Real Water of Tennessee. That good faith determination has been granted, and a stipulation in order of dismissal with prejudice has been entered. We have also tentatively resolved the third-party claim against Gold Coast, and motions for good faith determination and a proposed stipulation and order will be forthcoming. So as far as UNFW's portion of the third-party complaint is concerned, we believe those matters to be largely resolved, or all but resolved, if you will. I'll set aside whatever Mr. Kemp is asserting on behalf of the Gallaghers in count 4 and against the insurance companies separately. But we did want to make clear that I think Mr. Kemp and I are on the same page, and UNFW is done, and whatever is going forward is the plaintiffs and the plaintiffs alone.
Mr. Kemp?
I think that's pretty accurate, Your Honor.
Okay. All right, anything else? Okay, in light of that, I'll go ahead and grant it. Prepare the order. Let's move to the next matter.
Your Honor, the next one I think would be the motion to strike, and when I lay out a little background here.
Your Honor, before we do that, it seems to me, and we've argued this in our papers, the motion to sever really should be addressed first, because if you grant it, and the appropriate remedy for that, we would say, is the severance of the claims against Liberty into a new action to be randomly assigned to a new judge. If you were to agree with that, Your Honor, then every other motion should be addressed by that new judge.
Well, I don't know if I've had severance before and I kept the case.
Well, Your Honor, if I may,
Go ahead.
for instance, here, our motion to sever is based on a violation of Rule 14. Rule 14 makes very clear when a third-party defendant can be brought in by a plaintiff. Rule 14 says a plaintiff can bring in a third party if it has a claim asserted against the plaintiff, and they're saying that that claim, or rather the third party defendant, is liable for that claim. Well, here, Your Honor, no claim has been asserted against plaintiffs, much less a claim for which Liberty may be liable.
Okay.
That's the end of
Here's
that's
the bottom line is
analysis.
this. I mean, I don't know if that's true or not. I have some thoughts. I'm not gonna make a decision on any of this right now. We might as well start arguing, because I'm gonna have some questions.
And if I may, you said you didn't know what was true or not, so I can address that properly.
No, I'm gonna give you a chance to argue.
I understand, Your Honor. My apologies.
I'm not cutting anybody off.
Understood, Your
Where
Honor.
do you want to start, Judge? I don't care.
It doesn't matter to me either. I just want to hear it because I have some questions.
I can pose that, or we can go back to the motion to strike, whatever you want to do.
Which one was filed first?
The motion to sever was filed first.
Go ahead.
And if I may, Your Honor, I haven't completed my thoughts. My apologies, Mr. Kemp. I didn't mean to interject. But, Your Honor, there is a clear violation of Rule 14. It is indisputable. And why do I say that? Again, Rule 14 requires that a claim have been filed against the plaintiff for the plaintiff to bring in another third party. In the 15 pages of opposition filed by Mr. Kemp's office, they don't dispute. No claim was filed against the Gallagher plaintiffs or any of the third party plaintiffs. That is the beginning and the end of the analysis, because there was no claim filed against the third party plaintiffs. They could not, under Rule 14, bring in Liberty as a third party defendant in this case. Now, Your Honor, you mentioned, well, you've had many cases of claims or parties severed. What I think you meant by that is you're probably suggesting that you can just simply sever, perhaps for trial, the claims against Liberty into a separate matter to be dealt with. But, Your Honor, the only appropriate remedy here is to actually have the claims against Liberty and Liberty itself severed into a completely new case and have that new case signed to a new randomly assigned judge. And why do I say that, Your Honor? That's the only way you place the parties in the position they would have otherwise been, but for the Rule 14 violation. Now, it's clear why Mr. Kemp did what he did. By appending the claims against
But aren't you getting a second bite under those circumstances as to a peremptory challenge?
Your Honor, I would submit we never got the first bite.
I mean, you got the first bite. You can always file that, right, within the appropriate time period.
Your Honor, I'm glad you raised that. We did file a peremptory challenge in this matter. And that was less than 2 weeks ago.
And Judge Johnson decided what?
Judge Johnson said we could not, because we were part of an action that already existed in which the parties already exercised their peremptory challenges. And as you know, under the Nevada rules, there's only one peremptory challenge per side. Because of what Mr. Kemp did, that is to bring Liberty in the context of this action instead of a completely new action, my client has been deprived of a lot of things that would normally be afforded to a new defendant. For instance, the normal rules that apply to the orderly management of a case, a discovery stage, initial status conference, the pretrial disclosures. On top of that, Your Honor, to your point, we would have been entitled to file a peremptory challenge, but we were deprived, as Judge Johnson held, because they were already exercised in this case. Your Honor, if this case was brought as a separate action, there also would have been complete diversity between the parties. We would have been able to remove. We did try to remove them. And Mr. Kemp, kudos to his skill, argued to the federal court there wasn't complete diversity because we were included in all these other, we were included in this action where there's all these non-diverse defendants. My client had been deprived of all of that. They never had an opportunity to remove based on complete diversity because they were inappropriately brought into this action. They were never given an appropriate ability to file a peremptory challenge because they were inappropriately brought into this action. They were deprived of all the orderly case management issues or discovery rules that apply for a new action. And that all stems from The improper filing
Well,
of liberties.
I don't know if I agree with that, because I don't mind telling you this, that we've dealt with third-party practice in this department for a long time.
That's true.
Yeah, but my point is this, when we have new parties come in, we always adjust the scheduling order to be fair. We do.
Well, to your point, Your Honor, if this case were to stay before you, then I think that would be something to be addressed at the appropriate time. That is to have the orderly case management issues addressed. Now, Mr. Kemp has been aggressively going to the special master demanding discovery within 30 days. Well, that isn't appropriate. And Your Honor, we've already mentioned many times that a discovery master, or rather, the special master has no jurisdiction or scope over liberty because we never consented to that. That's an argument for another day. But, Your Honor, it's very clear as day. Our client was deprived of the ability to bring a peremptory challenge. Our client was deprived of the ability to remove because of how this case was brought against liberty in the context of this case. And there is a clear violation of Rule 14. That rule specifies if and only when a plaintiff can bring a third party in. And again, there had to have been a claim against his clients. For that to happen, there was no such claim. They do not dispute that. That's the end of the analysis. There was a Rule 14 violation. And again, to place the parties in the position they should have been, this case should be severed into a new action with a new case number. And our client should be able to exercise the normal rights that he normally would do. And I should amend that, Your Honor. The other remedy, candidly, is to dismiss the liberty defense because they were not properly bought in. This is really a half step to really get to where we should be. Because of course, I know Mr. Kemp is going to pursue these claims. In response, I apologize, Your Honor.
No, go ahead. I thought you were done, but are you done or anything else?
There were a number of arguments made by Mr. Kemp's firm in opposition in the opposition papers.
And you can address them all. You can address them all.
Thank you, Your Honor. Those opposition papers were served 2 days ago. He first argues that Liberty waived its rights to bring this motion to sever. His first argument is that, well, this case has been around for 11 months. Well, Your Honor, this case had been in federal court for pretty much all that time. There would have been no need to bring a motion to sever. By virtue of the fact that this case was removed, the case was severed. And we do quarrel with the notion that we didn't raise this issue in federal court. We did actually too. In opposition to Mr. Kemp's motion to remand, we said there was a fraudulent misjoinder, that the case against Liberty in this case should have been brought in a separate new action. So we did raise it. Mr. Kemp's firm also says we waived the right to sever because we attended a special master hearing. I'm not sure how we could have waived a right to sever this case based on a special master hearing for which we only had 2 days notice of. And really it's irrelevant because we actually objected to the jurisdiction of that special master. Mr. Kemp also contends we've waived our right to sever because we filed a preemptory challenge. We had to, Your Honor, to preserve our rights. Under the rules, to file a preemptory challenge, it must be done in advance of a hearing on any motion. So we couldn't have had a severance motion heard prior to the filing of a preemptory challenge. We had to file that preemptory challenge first. Again, of course, that's not a waiver of our right to move to seven or to raise this Rule 14 violation. Mr. Kemp also raises this issue that there must be a 5-factor analysis to determine whether the claim should be severed. The cases upon which he relies upon deal with cases where the party was properly a party, was properly adjoined, not a Rule 14 violation. This is different. Liberty should never have been part of this case because there was no compliance with Rule 14. Counsel may also argue that there's some prejudice because he'll be denied discovery. Well, Your Honor, if there's a delay in discovery, it's not undue. We are in the position we are at today because of the strategic decision that was made by Mr. Kemp's firm to pen the claims against Liberty in this action. We are now in a position where we have to correct that. If Mr. Kemp had filed a separate action in 2023, almost a year ago, we would be knee deep in discovery. So insofar as there is any delay, that is because of Mr. Kemp's decision of how they were going to proceed with this case. And with that, Your Honor, I'm willing to address any questions you may have, or to reserve the ability to rebut anything that Mr. Kemp may have to say on the motion to sever.
Thank you. Mr. Kemp.
Well, Judge, I think it's pretty clear, counsel's admitted it, that what they're doing here is judge shopping. And this whole thing's been judge shopping from day one. So we filed the third party complaint in November 2023. They removed not all the third party complaint, they removed their portion of the third party complaint to bankruptcy court and argued that it was related to the bankruptcy. I've never seen anyone chop up part of a third party complaint and remove it. But anyway, that was a tactic to effectuate delay. We filed a motion to remand. Bankruptcy court granted the motion to remand. Contrary to counsel's representation, the diversity was not the only factor relied upon by the bankruptcy judge. There's a lot of factors. I don't want to go into them. I just want to make the judge shopping point. So the bankruptcy judge sends it back here. And then they immediately do their second judge shop. They file a peremptory challenge, despite the fact we have a, I can't remember if it's 2022, 2023 case from the Nevada Supreme Court that makes it crystal clear that they had absolutely no right to do a peremptory challenge. So we filed a motion to strike. Judge Johnson struck their peremptory challenge as she should have. All right, so the first two judge shopping tricks didn't work. Now they want you to sever this complaint under some kind of misguided notion that when you sever something, it flies off to another department. Okay, so basically they want you to sever it and recuse yourself because they want some kind of additional peremptory that no one else has under the Supreme Court rules. And I point out they haven't challenged Judge Johnson's decision in any way. So we get to the real reason for the motion. We went to the special master hearing, and the special master ordered that they have to respond to 40 document requests. The response date is passed. He also ordered that if they do not produce the documents they claim privilege, they have to file a detailed privilege order in accordance with the Nevada rules. So last Friday, they filed some sort of objection, didn't produce one single document, didn't file any privilege log, basically flaunted the special master's order, which, by the way, is a final order that has not been appealed from. You know, they challenged his jurisdiction. He said, I have jurisdiction. He ordered the discovery be produced. That's not appealed from.
I mean, the special master is just an arm of this court.
Yeah, we're done on that. So
I mean, that's all it is.
The counsel says, oh, we haven't started discovery. Well, we haven't started discovery because he's hiding all his documents. And we have produced 100,000 documents in our 16-1 disclosure. 100,000 documents, and they haven't produced one piece of paper despite an order from the special master. So they say, well, we got to start this case over again somewhere else. So now maybe we can remove it for another reason. We can do peremptories. You know, this is just more judge shopping, Your Honor, and it's improper. The federal bankruptcy court found it was improper, the removal. Judge Johnson found it was improper. And now they come to you and they say, oh, you've got to sever. And the argument they make in their pleading is the claims in this case have nothing to do with the Gallagher action. Absolutely nothing to do with the Gallagher action, not related to it. Claims against Liberty, not related to the alleged personal injury claims, unquote. That's their primary argument, okay? So let's talk about the claims in this action. When the Gallagher trial was proceeding, if the court recalls, offers of judgment were made in relatively small amounts. Some were $425,000, others were a little more, but relatively small amounts. So Liberty rejected all those offers of judgment. And then we started the motions practice in the Gallagher case. The only reason the Gallagher case was going forward is we made an agreement with the bankruptcy trustee that we would waive all our claims against the real water assets.
I
And
understand.
in return, we could continue.
And that was to
this-
seek relief from the automatic state of proceeding.
That's right, Your Honor.
I get it.
And remember, at the time we made that agreement, there was a potential that
And
real
tell me
water
what was
would
going
have.
on, because I mean, you guys know I've been busy. What happened with the bankruptcy trustee and whatever negotiations or attempts?
This is what happened, Your Honor.
Because
So.
I want to make sure I understand
So
what's
we
going
entered
on.
into the agreement with him. The bankruptcy court approves it. That if we give up our claim against Real Water, and remember, that was before they found the rocket fuel.
Right.
Okay, there was still some hope they could sell the Real Water business for 10, 12, 30 million bucks, whatever. But there was thought that there was gonna be money there. All right, when they found the rocket fuel, it turned out to be a dry hole. There's no money in the state. But anyway, we waived our claim against. And in turn, we got the right to go against
Insurance proceeds.
the insurance proceeds. Exactly.
I get
And
it.
so now we fast forward, and so that goes along for like 8 to 9 months. 100 depositions are taken. We file 100 pretrial motions. We're in here arguing with Your Honor, and we're on day 3 of the pretrial motions. And apparently, Liberty doesn't like the way things are going because they go back to the bankruptcy trustee and they say, "Oh, we're so sorry that you've done all this work and that this is a dry hole and you're not gonna be able to sell the plant. What if we give you $400,000?" And this is in a written settlement agreement that they are paying the bankruptcy trustee $400,000. All you have to do for us is 3 things. 1, repudiate your agreement with the plaintiffs, allowing them to proceed. Okay, that's the intentional interference of contract, Your Honor. 2, talk the court into giving a full and complete release to Liberty. And 3, we're gonna graciously give you $3.6 million. And a couple of weeks ago, they conceded that the insurance proceeds were 22 million. Now they're trying to complete 22 million. So they come in and they say, so here's $4 million. Everyone's gonna be happy, happy, happy. But the linchpin of the whole deal was the intentional interference with contract. And then the absolute worst thing, they had actually settled on behalf of Real Water with the Gallagher baby, but the Gallagher baby was continuing his claim against Milwaukee, another Liberty insurer. So despite the fact they had settled with the Gallagher baby, they got the bankruptcy trustee, and this is part of the settlement agreement. It's spelled out in a separate paragraph. The bankruptcy trustee filed a federal injunction suit against the 7 Gallagher plaintiffs to stop the entire Gallagher trial. So not only
How
did
could they do that?
I've seen insurance companies do some things that I don't think they should be proud of, but I've never seen an insurance company engaging in an intentional tort like this, an intentional interference of contract. No question that they knew there was a contract. It's laid out in the settlement agreement. Okay. No question that it was intentional. They required an injunction suit to be filed. Luckily we went in front. At the same time we were arguing motions with Your Honor, I was arguing an injunction hearing with Judge Cox. And that's the bankruptcy judge. And she says, "I'm not going to enjoin the state court. Are you crazy?" And so denied the request for TRO. All right. She didn't say it quite that strong, Your Honor, but that was the gist of it. So then what happens? Then we tried the Gallagher case.
I don't know how you could enjoin a state court action from going forward to a jury
I
trial.
forgot one part, Your Honor. We had a mediation set up with Milwaukee with Judge Gonzalez. We went one time and we had a second one and we thought we were getting somewhere. But then the Liberty Counsel, 2 days before the second mediation, they stop it because their little trick is going to work in bankruptcy court. They're going to get the injunction. So why waste money? The Gallagher case is going to go away. So this is what this insurance company did. Okay, I've never seen a more blatant interference of contract. Never. I've never seen it. And I would point out that they represented to the bankruptcy judge that this was a contract, that this was an agreement. They're trying to wiggle out of it now, saying, oh, it's not an agreement, it's not a contract. But when we argued for the bankruptcy judge, the attorney for Liberty called it a contract agreement. All right. So their argument is that this effort of theirs to torpedo the entire Gallagher trial, the interference of contract is not related to the alleged personal injury claims. Your Honor, how could it be more related? They tried to kill the trial. It is directly related. So for purposes of severance, that's the end of the analysis. Okay, that is the complete end of the analysis. The claim is proper here. And think of what counsel's asking you. Okay, Judge, this matter is so complicated. I want you to send it to another judge in this district, so maybe we can buffalo him or her. That's what he wants to do. Or maybe I can file another removal, even though, my first one was frivolous, I got sent back. I'll try another removal. Because this is the whole program here at Liberty. They want to delay and disrupt. Delay the proceeding and disrupt the proceeding. That's the whole claim here. And you're going to find during the litigation, Your Honor, that this is a business tactic of theirs. But back to the severance motion. There's no valid grounds for severance here. None whatsoever. I mean, trying to get out from the special master order you've already violated, that's not reason for a severance. Trying to get another peremptory because Judge Johnson denied the first one you filed, that's not reason for severance. Trying to create some basis for another removal after your first removal failed, that's not the grounds for severance. And that is what they're tendering is the reason for severance. And so for that reason, we think the motion to sever should be denied.
If I may, Your Honor.
Yes.
So Mr. Kemp does a very good job of spinning the tail, and I'd like to address some of the misstatements made here. First of all, while he likes to point to me and say Liberty's doing this and that, I'm not the counsel for Liberty in connection with the bankruptcy.
Well, I don't think it was meant to be personal. He was talking about the party.
Just wanted to make that clear.
I understand.
But I
What
do
about
know.
the injunctive relief and try to stop or prevent the Gallagher case from going to trial?
I do know, Your Honor, that we do vehemently disagree with his characterization of what's happened.
But I mean, but here's that would be something I think that would be not a question of fact. If they attempted to seek injunctive relief to prevent the Gallagher case from going to trial.
That may
right?
Whether what that is, what happened, that may be so. That can be litigated at the appropriate time. And
So why can't that be litigated in this case?
It can be litigated against the claims against Liberty, but that's not before you, Your Honor. The question before you is.
And when was the third party complaint filed? I want to take a look at that.
It was November of 2023, Your Honor.
I want to see what's in there.
Sure, Your Honor. But I'd like to address, if I may, some of these issues. I would agree with Mr. Kemp that from day one, this issue is about judge shopping, but it's not Liberty who was judge shopping. It was Mr. Kemp's firm. Again, there is a clear violation of Rule 14. When he tried to amend, and he did successfully amend, the complaint in this action to include the Liberty defendants. Clearly, he did that, Your Honor, to place the Liberty claims, the claims against Liberty before you, and also impose roadblocks against us if we wanted to file a peremptory challenge, or if we wanted to remove. To say that we were engaging in forum shopping in the first instance is obviously not true. Liberty was really trying to exercise the rights it would normally have if the action was filed as a separate new action.
But I mean, if Liberty wanted to file just go ahead. I'm thinking about another issue, but go ahead.
Okay, Your Honor. Thank you very much. Mr. Kemp also mischaracterizes the basis of our motion to sever. The basis of the motion isn't that the claims are not related in some tangential way to the Gallagher action. Again, I'd ask you just to look at Rule 14. Rule 14 specifies subdivision B when a plaintiff may bring in a third party. So it tells you when a plaintiff can bring in a third party. And that is, quote, when a claim is asserted against a plaintiff, the plaintiff may bring in a third party if this rule would allow a defendant to do so. And if you go to subdivision A, a defendant may bring in a third party when a claim is asserted against him for which the third party defendant may be liable for. That is the crux of our motion, Your Honor. Did they appropriately bring Liberty in as a third party defendant? Plaintiffs had no claim asserted against them. They don't deny it in the papers. Mr. Kemp does not deny it here in court. Because there's no claim asserted against plaintiff, they had no right under Rule 14 to bring Liberty in as a third party defendant. What they should have done was to file a completely separate new action against Liberty. That's the crux of the motion. Don't be fooled, Your Honor. It's not that it's unrelated or related. That's the crux of the motion, of our motion to sever. As there's no dispute of the salient facts, there's clearly been a violation of Rule 14. And again, the remedy, the appropriate remedy is to place the parties back in the position they should be, and that is to have this severed into a completely separate action. Now, Mr. Kemp says, this court can't do that. Well, no, Your Honor, this court has the plenary jurisdiction and the Chief Justice has the plenary jurisdiction to do justice, and you can do that. Now, if you disagree, Your Honor, that you can't do that, then the actual remedy is dismissal of the claims against Liberty. Because again, Liberty's not a proper third-party defendant in this case. That's the beginning and the end of the analysis.
Okay. Let's go on to the next issue.
Well, Your Honor, if I may, just one thing, and I don't want to leave it.
No, I don't want to cut you off.
I don't want to leave it hanging out there. Counsel argues that the special master discovery issue is done and over. We completely disagree. I'd urge this court, well, if not now at the appropriate time, Rule 53 is very clear. A special master can be used to address issues that the court would otherwise address if the parties consent. Liberty was not a party in this action in 2021 when all the parties entered into a stipulation to the use of a special master. Liberty was brought into this action in 2023. We never consented to the use of a special master. Any discovery issues, any other issues need to be addressed by this court, unless at some point in time, Liberty does consent to a use of a special master. So we totally disagree vehemently to this issue that the special master can have any scope or authority over discovery issues here. As for that, Your Honor, I'm willing to submit. I'm happy to move on to the next motion.
Yeah, let's move on to the next one.
Your Honor, this is our motion to strike. So basically what happened here is they went over to federal court and they filed a motion to dismiss that primarily relied upon litigation privilege. And I don't know how interfering with our contract by giving the trustee 400 grand and doing a separate contract with him requiring.
Well, you know, litigation privilege deals primarily with statements made, not actions.
Communications in court
Yes.
by an attorney.
Right.
Okay, so this is their litigation, and I don't want to get in the merits of that, Your Honor.
I understand.
I just want to say that the litigation privilege argument that they raised in federal court, that I filed an opposition to, they filed a reply to, we were set to argue it in front of the bankruptcy court. And that morning she announced her decision on the remand, so she left that to the state court. So anyway, I wrote them a letter and I said, hey, you know, you got this motion to dismiss outstanding. I know you want to get it resolved. So can we do this on the week of the September 23rd? I'm fine. So we can do it on the next week, 9:30. They didn't respond. They didn't want to hear their actual motion to dismiss. He wrote me a letter saying, oh, no, your complaint's so screwed up, you got to file a new one, and then we're going to file a new motion to dismiss, and we're going to drag this thing out till March. You know, I decided that wasn't a good way to go. So they went to the special master hearing, and the special master said, you have to do this discovery. And they said, oh, no, we're not going to do discovery. We're going to file a slap motion to stop the discovery. And the special master said, well, wait a minute, that's not going to work. Okay. And they made their argument. He ordered they do the discovery. And, you know,
And I don't mind telling you this. I looked at the slab motion. I have thoughts on that.
yeah, Judge, we're not arguing the slap.
Yeah, I
motion?
understand.
Okay. We're not arguing the slap motion, and I don't want to argue the slap motion. Because see, the tactic here is to argue the slap motion, then they'll take an appeal to the Nevada Supreme Court and they'll get a stay during the entire time period. So that brings me back to federal court. So they filed the litigation privilege and a motion to dismiss in federal court. Why didn't they file the slap motion in federal court? Because you're supposed to file the slap motion in federal court. You can file the slap motion in federal court. There's at least two Nevada Ninth Circuit cases that say exactly that. Okay, relatively recent. So there's absolutely no reason they couldn't file a slap motion. But they
Well,
did.
I would think you would be required to file it in federal court.
Well,
And I mean,
yeah.
I looked at the 20-day time.
Must do it in 60 days, should be
Right,
must do it. But here's why they didn't do it, Your Honor. Because in federal courts, there's no automatic stay of discovery. Federal court has said, oh, you know, for Erie Tompkins purposes, we're gonna allow our own discovery. So that's why. they didn't file.
Is that, I actually have a note, there's an Erie doctorate issue in this
Right,
case.
But
I actually thought about
I
that.
don't think they dispute that they could have filed it in federal court, and if they do dispute it, you know, we have we've already cited the Ninth Circuit cases. So really, this boils down to one little issue. Does the word must mean must,
It's mandatory.
or does it mean may?
No, it's mandatory.
So our slap statute was taken from the California slap statute, which I'm sure counsel is familiar with since they're from California. But California says may. California doesn't say must. Our statute says must. Must is mandatory, Your Honor. They have to file it within 60 days. And if they don't file within 60 days, the time is gone. So, and they didn't file it within 60 days. I think they were 290 days late. So my problem with this slap motion is it's not timely. And that's why we asked for an order shortening time, Your Honor, on this, because our opposition is technically due to that tomorrow. And so I don't know how or when the court's gonna decide this, but if it's not decided before tomorrow, I would like at least, you know, an extension of time for.
I'll stay the opposition or
Thank
the
you.
reply time until I may issue a decision. I don't want lawyers to do unnecessary work.
Hey, Your Honor, and so, and I want to make it clear here. I am not saying they can't raise this litigation privilege. Okay, I'm not saying that. They've got a motion to dismiss pending that I suggested we argue 9:23, 9:30 to get it out of the way. Okay, I want that, they can argue that anytime they want. We can do it tomorrow if they want. All right, so I am not trying in any way, shape, or form to foreclose them from arguing this litigation privilege in the motion to dismiss. But I am saying that they can't do it in a slap motion because it's too late. And the reason for that is they say that there's good cause for letting them do it late. Well, there's no good cause, Your Honor. I offered to let them do it 30 days ago and they said no. All right, they could have filed this litigation or argued the litigation privilege 30 days ago and they didn't want to do it. So there's no good cause. And they've shown no good cause for why they didn't file it in federal court. I mean, 273 days late. There's just no reason. And then finally, Your Honor, we there's another improper motive here. We quoted the exchange between the special master and counsel, where the special master said, you've got to produce the documents. And they said, oh, we're going to file a slap motion. We don't have to do anything. The whole reason for this is to get out from under the special master order. And like I've already said, they didn't appeal that order in time. That's a final order. Okay, they had an opportunity or right to appeal it to Your Honor. They didn't do that. So they chose to live with the special master's order and they're bound with it. So in any event, for that reason, we think the motion to strike should be granted.
All right.
And Your Honor, before I renew my offer, I'll come tomorrow, next week, anytime he wants to argue this motion to dismiss, I'm fine.
So, Your Honor, I'm just thinking about where to start. I do want to at least maybe clarify some of the issues or misstatements that I think are misstatements. Mr. Kemp talked about how we didn't respond to his offer to have re-notice the motion to dismiss hearing. that was filed in federal court immediately in state court. But then in the very next statement, he did say we did respond. And we advised facts have changed. Clearly, the facts had changed. The third party complaint against Liberty was based on conduct on the engagement of settlement communications, dealing with the dispute over amounts owed under insurance policies issued by Liberty. Well, that settlement was never approved. It was replaced. It was annulled. Clearly, those operative facts are different. And so we asked counsel if he's going to amend. He never responded to us. So that is a misstatement. Counsel also said, oh, well, we offered to hear this anti-SLAPP motion in 30 days. Well, no, he never said that. He was talking about the prior motion to dismiss. I just want to clarify, I don't want these statements in the air being considered to be true just because I haven't addressed them. Counsel says he doesn't want to argue the anti-SLAPP motion, and then he proceeds to argue the anti-SLAPP motion, Your Honor. I will not belabor the point about why the anti-SLAPP motion applies, except only to say, if you want to see our papers, Your Honor, you'll see we cite many authorities that say anti-SLAPP under Nevada law applies not just to communications, but to conduct. It doesn't apply just to attorneys, but to parties. Contrary to what Mr. Kemp just said, that's case law. We've said, and we do think the litigation privilege does apply. Well, let's get to the point of the real part of the motion, Your Honor, this emergency motion to strike. The basis of the emergency motion to strike was the argument that we failed to comply with Nevada's rule that a motion to strike, the anti-SLAPP motion must be filed within 60 days. Well, Your Honor, if you only consider the time during which this action was in state court, there's no dispute. We did file within 60 days. Now, I understand.
Well, my question is this, where does it say that potentially there's a tolling when a case is pending in federal court?
I would point you to two cases, Your Honor. The Sarver case, one, which is a Ninth Circuit case, came out in 2011.
I looked at that and I had questions regarding, isn't that the case that said that this was a procedural issue?
It said very clearly the 60-day limitation dealing with when you file anti-SLAPP motion is a procedural issue, which
How can that be? It's not in the rules of civil procedure. That's a statutory grant given by our Nevada legislature. And that's when I thought about Erie versus Tompkins and the Erie doctrine, right? And we have specific Nevada cases that deal with the interpretation of statutes. And for example, we have Fry versus Levin. And it really focuses on whether substantial compliance is required and or strict compliance is required in a case. And it's pretty clear. You look at the statute, and if it's a time and manner statute, and that's what this appears to be, it has to be strictly construed. Because I don't mind telling you this.
Yes.
I saw that Ninth Circuit. It jumped off the page at me. And I said, wait a second. I wrote on my little tab here, Erie doc. That's what I thought about when I heard that. And I don't mind saying it. I don't see how that Ninth Circuit case is controlling, because at the end of the day, this is a Nevada statute, and we've granted specific rights as it relates to anti-SLAPP. And then there's a requirement that it's to be done, must be done within 60 days, unless I make a determination that there's good cause for it. I've heard no good cause analysis. Typically under Nevada law, when we deal with good cause, diligence is a component of good cause. Almost every case that deals with good cause has a diligence component to it, right?
Happy to address that, Your Honor.
Go ahead.
Okay. So I can only represent to you, Your Honor, what the Ninth Circuit held. I understand what the Ninth Circuit might say is not binding on this court, but it does go to the issue of the 60 days, and it goes more importantly to the issue of good cause. And I'll get to those points in a moment. But we know Sagar says that this 60-day limitation, they consider it, right or wrong, Your Honor, as a procedural limit.
Well, here's my point. Realistically, if they wanted to know the true answer, they could have certified that to the Nevada Supreme Court. because it's an issue of statutory construction, right? And it's a grant. I mean, it's not a procedural rule. It's not. It really isn't. It's like any other statute we have in place that deals specifically with grants given by our Nevada legislature with a specific time period to exercise those rights.
Understood, Your Honor.
I mean, that's how I see it. And the reason why I wanted to do that, I wanted to clarify the record as to how I see it. I don't know what was raised in the Ninth Circuit case, but, and just as important too, it's my recollection. I did look at the Nevada case. What's the seminal case on, anti-SLAPP? Which case is that again?
Your Honor, I think that's Justice Pergary's, the one where he says that,
What's the site on that again?
Your Honor, we cited in the brief. Let me see if I can find it. That's the one that says, Nevada's limited. That's the one where the attorney tried to, swindle.
I have it. I bought my books on it. I didn't
He
have
tried
it.
to, I can't remember if he was trying to cheat his expert or cheat the copy company, but he tried to cheat him by saying that the recovery is one thing, it was another, and tried to discount their amounts. And when he was sued, he argued litigation privilege, and so everything goes away. And
Was that the panic case, Your Honor?
Justice Pergary said, no, you look at the gravamen of the conduct, or gravamen of the complaint, excuse me. And so it didn't apply to conduct, as counsel indicates. It just applies to communications. California law is different, Your Honor.
Well, I understand. I understand we have a Nevada case that specifically dealt with, when it came to anti-SLAPP, we looked at California law as far as the conduct. I get that, but there's a distinction between California and Nevada as to statutory interpretation when it comes to specific rights and deadlines set forth in a statute. And the Nevada statute is different from California. Must versus may is a significant difference. And just as important too. And I'm looking at it, and I think it's good to have this rigorous discussion, because what would be the good cause for the delay? Why couldn't this motion have been filed in federal court?
So I wasn't, Your Honor, if I may.
Yes.
I was going to address that point, although you made a number of points on what I want to address as well. Let me just make a note. So, Your Honor, even if you were to ignore or say SARVA doesn't apply or there are eerie issues, one thing I would say right off the bat, Your Honor, is that sounds like something we need to brief, because clearly it wasn't briefed by either side, and we want our opportunity to address that issue. But notwithstanding that, Your Honor, the SARVA case provides pretty good reasons for why Liberty did not have to file within 60 days. It may be at the end of the day, Your Honor, that there was a disagreement over its applicability, but it clearly said in that Ninth Circuit case in which we were in at the time, that the procedural limitation of having to file an anti-SLAPP motion within 60 days doesn't apply. As for the other factors for good cause, Your Honor, we were removed. They immediately filed a motion for remand. We also did file a motion to dismiss, which did raise the litigation.
I got a question for you. Why wasn't it filed in federal court?
Your Honor, I can't speak to the specific discussions we've had, of course, but I can tell you this, Your Honor. The motion to dismiss raised two very substantive grounds. I disagree with counsel that the litigation conduct privilege was the main one, although it was a very important one. But it was also based on the federal preemption rights. If the court were to agree, the bankruptcy court would agree that the matter was related to bankruptcy issues, then clearly federal preemption arguments and doctrine that was set forth in the motion to dismiss would have taken the case out of, would have resulted in the dismissal of the case. In due course, Your Honor, an anti-SLAPP motion would have been filed, but that case had been mired, Your Honor, in just limbo. And the reason for it is the bankruptcy court had discharged the use of its law clerk. And so it took months to address issues. For instance, we know the motion for remand wasn't decided till, I believe it was 8 or 9 months later. I would also say,
But I mean, at the end of the day, there might have been issues there, but why couldn't the motion have been filed within the statutory mandate?
well, again, Your Honor, if we had a quick decision on the motion for remand, for instance, If it had been denied, then, Your Honor, we would have felt more at liberty to proceed with the anti-SLAPP motion and the motion to dismiss. But even the motion to dismiss wasn't ruled upon. And in fact, at the end of the day, it wouldn't have made a difference, right, Your Honor? Because the motion to
But
dismiss
see,
wasn't
here's my
ruled upon.
point, though. I mean, I get it, and I understand there are delays in federal court. I think, wasn't it a 204-day delay or something like that somewhere I read? But my point is this: when you have a statutory mandate that says must within 60 days, you got to follow that.
I would say, Your Honor, that in this case, when in federal court, I can only rely on the fact that that rule did not apply according to Sarver. I would also say there was a second case. There's the Morin case, the South Sutter case. The Morin case, Your Honor,
Are these any cases involving the interpretation of Nevada law?
it's California law. I concede that, Your Honor. Both South Sutter and Morin deal with California law. But I would say the analysis.
And no, I think there's a big difference in the analysis, because when you say may versus must takes away this court's discretion.
I would say on first blush, it sounds correct, Your Honor, but it's not. And I'll tell you why. The may use of the word may under the California anti-SLAPP statutes is treated as mandatory. It's treated exactly the same as the Nevada courts use the must language. And I'll tell you, I'll cite two cases, Your Honor, I'm happy to have you look at. You can look at.
I'm gonna be candid with you. I'm gonna look at California cases. I mean, I want to be really clear, because I can cite for you right now, Fry versus Levin, and it deals specifically with this issue. And
the analysis would not be different, Your Honor, in the sense that even regardless of the fact that California uses the word may file within 60 days, it's been treated as saying if it's after 60 days, it's not allowed unless the court allows it, which is effectively the same as the Nevada rule as it concerns the timing for the filing of an anti-SLAPP statute.
well, this is what Nevada says when it comes to issues of compliance with the statute. And we have a distinction between strict versus substantial compliance based upon the statutory language set forth therein. And under Nevada law, if it's an issue regarding time and manner, strict compliance is required. And that's Levin versus Fry, 123 Nevada, 399. It's a 2007 case, and it's clear. And I looked at the statute, and it said anytime I see must, that means it's mandatory to me. And if it's not done within that time period, there's only one way out, and it's good cause. And in every good cause case I've read, there's always a diligence component to it as part of the court's analysis. And I don't mind telling you this. I read all these cases.
And I appreciate that, Your Honor, but then I have some additional cases you might want to read. And I'll be so clarified.
But here's the thing. I don't need clarification when it comes to statutory construction under Fry versus Levin. Our Nevada Supreme, I mean, I'll give you the site. And they say this is how you interpret it. I don't mind saying it. In 19 years, I've been following the mandate of Fry versus Levin.
Understood, Your Honor. But the underlying analysis you've just enunciated is that California treats the word may differently from how Nevada uses the word must, right? And
Isn't this a Nevada case?
which this is, yes, Your Honor.
I don't care. And you know, here's the thing you have to understand. I understand you're from California. I think there's this conception that Nevada is lockstep with California. And that's so untrue, especially in tort cases, even cases involving insurance and the like. For example, our med pay laws are different than California. There's no credit given for med pay under Nevada law, right? I mean, we look at, when it comes to collateral source, that's different in Nevada than it is in California. I mean, and I can just, if you want me to, I give you a whole list of a lot of things, but that's just based upon my experience. We do things differently. And I understand we looked at California when it came to anti-SLAPP statute because it was very similar. But then after we define the term as to what would come under anti-SLAPP, yes, we can look to California for that because that's what the Nevada Supreme Court said. But then there's other parts to the statute which has a mandatory requirement unless I make a determination as to good cause. And I'll be candid with you. And I'm not going to make a decision today, but I'll put this on the record. I don't think the fact that a case is pending in federal court where you can file an anti-SLAPP motion and you fail to do so can reach the level of good cause.
So, Your Honor, I do not presume that I can come in here and explain that California court law should apply. It's not how I was raised.
It's not gonna apply.
No, Your Honor, all I'm saying is this. In the absence of Nevada precedent, we know there's cases that say you look to California. That is the only reason. And I don't mean to presume that it should have any more effect than it should, than you would otherwise provide it in an ordinary due course. I would only submit for the record, Your Honor, the following cases, which make clear the timing limitation in California's anti-SLAPP statute is mandatory as well. And if that has any relevance, Your Honor, I submit it for your consideration. The cases are Hewlett Packard Company versus Oracle Corp, 239 Cal 4th 1174, pin site 1187. There it says the special motion may be filed within 60 days of the service of the complaint or in the court's discretion at any later time upon time to make.
I'm not given that discretion.
Your Honor, if I may.
No, but I'm serious though. You say that, but I'm not given that discretion.
Judge, I don't want to interrupt counsel,
Yeah.
but I was going to waive my reply because we have a jury waiting
Yeah.
to the punitive phase. So perhaps we could continue this argument until after we do the punitive arguments.
You do have discretion under the Nevada statute because you can extend the 60 days for good cause. So I'm not sure I quite understand the statement.
Well, no, it's number one, I don't have discretion. I have to make a determination as to whether there's good cause or not.
Understood. And I don't see that as distinct from the California cases I'm saying. That's the point I'm making, Your Honor.
Well, and before we break, I see a big difference between must and may. And the Nevada law is pretty clear in that regard. And I will say this for the record, from a case perspective, I'm going to follow the mandate of our Nevada Supreme Court when it comes to Levin versus Fry. And the mandate there as to how I interpret statutes, and I don't mind saying that I've always followed the mandate of Levin versus Fry, 123 Nevada 399. And from what I understand, it's good law, and they make a distinction between strict compliance and substantial compliance. And if the statute focuses on time and manner requirements, it'll be strictly construed.
To that extent, Your Honor, may I ask that the parties be given the opportunity to brief this? Because this wasn't raised by counsel, certainly.
Judge,
Yeah.
no.
Why? It was not raised, Your Honor. This is an issue you're raising.
Emergency motion for order shorting time.
Well, here's the point.
No, your motion to strike is on
Yeah,
OST.
here's my point, and it's really this important.
It's in the brief, Your Honor.
Wait, let me finish. I read the points in the case, right, yesterday after trial, and I went through it. And there are certain things when I read the points and authorities just jumped off the page. An attempt was to persuade me to follow California law, and I looked at the Ninth Circuit case, and the first thing I said, this is so clear. This is an Erie doctrine issue. We're dealing with the substantive law of the state of Nevada. We're not dealing with procedural rules. And it's clear to me, I don't need any supplementation on that issue. Because has Erie versus Tompkins been overruled? I don't think so. And so anyway, anything else, because I do have a jury sitting out here, and I'm gonna go back and I'm gonna read everything. And I don't mind telling you this, and I do this all the time. If I feel I have a need for supplementation, I invite it.
Thank you, Your Honor.
Yes. Let's go ahead. It's 11. What time did we tell them to come back?
10:30.
All right. And what I'm going to do, I'll issue minute orders. I'm going to sit down. I didn't have a chance to, I read it, but I want to take another look at the third party complaint and just do another review. And I'll get minute orders out within a relatively recent time period. And then what I mean by that is sometime next week
Thank you, Your
or
Honor.
earlier.
Thank you, Your Honor. Oh, if I may, as a housekeeping matter, the anti-SLAPP motion is set to be heard next week, October 30th, but given your consideration of this,
30th, when is that can we move that 1 week?
I'm fine with that, Your Honor.
if I may, Your Honor.
Yeah, just move it
My
or
calendar.
1 week or more. We'll accommodate your schedule, sir. 1 week.
I
or more.
appreciate that, Your Honor. Okay, Your Honor.
Okay, so the next date would be November 6th.
How's that? Is that good for you, sir?
My apologies, Your Honor, one moment.
I'll take your time. Give me a railroad version.
It's not close.
1980.
I can still teach it. First day, most of the first day.
Your Honor, would the following week work because I do have a doctor's appointment?
Any objection to that?
No objection, Your Honor.
That'll work, sir.
The 13th, then, Your Honor?
All right, got that?
And Your Honor, yeah, I'm sorry, Your Honor, you're gonna provide a minute order if you even need that hearing. Is that correct?
Yes,
All right, thank you, Your Honor.
absolutely. Okay, everyone enjoy your day. Mr. Marshall, have you checked on the panel?
All right.